Amongst all the debate about China this week, we've had a contribution from Kevin Rudd, who says the foreign interference laws are required, but Australia should be cautious of racial profiling. Here he was talking at the book launch of Peter Harcher.
Maintain domestic vigilance against any substantive rather than imagined internal threats to our democracy, our political institutions and our critical infrastructure. China does this for its own country. We should do the same for our own and not apologise for it. However, a word of caution about foreign influence. It's very easy for this to translate into a form of racial profiling. I will be the first to the barricades if most recent national security legislation becomes a political vehicle for Hansonism and a return to the days of the yellow peril.
My first guest on the program is Labor MP Ed Husic here in the studio. Thanks for your time.
Thanks, Tom.
The yellow peril we could be returning to, or at least a warning we shouldn't go there. What did you make of that from your former leader?
Well, I think the nation can be very grateful to have someone with Kevin's expertise being able to put forward views in the way that he has. I think what he has done is sounded a very salutary warning. I mean, he's said on the one hand that foreign interference laws are very important for a country, but he's urged also not to go into overreach and not to go in a way that makes life difficult for others who just want to live their lives as Chinese Australians. And I think that it is, inexplicably, it's a solid, very useful, commonsensical advice from Kevin that we should, regardless of politics, take heed of. I think it's very timely.
Are you more Kevin Rudd than Paul Keating on China?
I don't see necessarily that they've formed into camps, and I've got different views with respect to, while I do take on board Paul's counsel and advice. I do think this is a serious issue, and you and I have previously spoken where I think that we should take a very robust stand in speaking up on human rights issues in China, particularly where those underpin or are a feature of a political system that allow for the growth of an economic stand or an economic strength in terms of China that's now manifesting itself in terms of diplomatic moves by China. I think it's really important for us to raise those issues and raise those concerns. And I don't, again, I take on board Kevin's view that, while this is something that we should definitely be mindful of, and China does it in its own, within its own domain, as it were, let's just not go too over the top on it.
What is the line of over the top? Because Labor still says Gladys Liu has more to explain. She says she was, in some cases, signed up to groups purely because she was Chinese. It wasn't her fault that she was signed up to groups connected to United Front, and Labor's saying that's not good enough?
I think that being able to demonstrate a degree of transparency about your involvement with other groups, particularly where there are questions about whether or not those groups are trying to exercise undue influence, I think those are completely valid questions.
So just more explanation from her.
Yeah, absolutely.
What about the Labor candidate in that seat, Taiwan-born Jennifer Yang? Because she had some reported links, again, perhaps, maybe one step removed, but links to United Front. Could we have an audit on both Chisholm candidates, given that's where Beijing was targeting?
I think if those questions are put forward, you have to answer those questions. I don't think transparency in respect to this is a bad thing. I think it's important, given where we're at, given that security agencies in particular are saying that we need to be mindful of these type of things. It's why, for example, Labor leader Anthony Albanese has called for a briefing on these things as well, to ensure that Labor is properly informed with the most up-to-date information.
Its own candidates going forward as well.
And I just think that you can't hurt it. And I've previously made the point, we've had to explain from our own backgrounds whether or not we not only satisfy Section 44 from a strictly legal perspective, but recognising too Section 44 is in place to be able to demonstrate there is no scope for foreign interference. If we've had to go through that as individual MPs, I think it's right, either as an MP or as a candidate, frankly, and I don't care if it's Labor or Liberal, you need to be able to answer those questions confidently and competently.
Could that just take the form of a security assessment, a risk assessment for every senator and MP?
I'm going to take the advice of others who think about this a lot more deeply and are in a position to exercise their expertise. But if they do make those recommendations, I think we should definitely listen very carefully to
You're not worried about that possibility? You think that could be, if that's the advice, take it?
Let's see what, if there is something that is concrete developed further.
All right.
Let's see what happens.
Encryption laws brought in by the government. I know this is one you followed closely. It happened in the last days, I think on the last day of the last government, actually. So this is the power to compel tech companies to provide access to encrypted data. There was a lot of talk about backdoor access and so on. We've had a bit of a please explain the US over this.
Yeah, they're rightly questioning whether or not the very thorough and well-considered arrangements that the US has in place for its companies on its soil that provides for that data to be accessed, particularly in terms of national security or elements of law enforcement.
That allows other countries to access
and they can access that data. You saw the US Congress, particularly the House Judiciary Committee, write to the Australian government, effectively, I think, questioning whether or not Australia should be entitled to access to that data, given that our own legislative arrangements are not as solid as what the US's are, because basically Peter Dutton ran through and ratted on a deal to put amendments inspired by the PJCIS, the bipartisan parliamentary committee that said fix your encryption laws. They ratted on the deal and refused to go to respond to that. Now the US is questioning whether or not they should allow Australia access under the US Cloud Act. And my blunt view is the US should not open up access. It should maintain its current position of not doing so until the government fixes its encryption laws and until it has a set of laws that allow the security agencies to do their job properly without weakening encryption that has a legitimate role.
So even though Labor helped pass this and said this is a security issue, you would say to the US, don't give us access.
No, let's be very clear. Labor agreed in December last year to pass those laws on the condition that was extended to us by Finance Minister Matthias Cormann and Leader in the Senate, that the debate would return in February this year, the amendments would be aired in government time, and if the amendments were consistent with what the bipartisan committee said, they would go through.
I understand that, but you're saying...
No, but sorry to interrupt, but I think it's very clear to point. We supported it on the basis of that condition, and the government ratted on that and passed through subpar laws on this that are now tripping them up.
I understand that, but you're saying the concerns about this are so great now that you would agree if the US essentially said, well, sorry, you can't have this direct access to do with the Cloud Act. So you would agree with that position if they took that?
Not only would I agree with that position personally as an individual parliamentarian, I would urge them to not provide access until the government ensures that its laws are fixed up and that it doesn't do anything to weaken encryption while allowing for a proper process to obtain data that's important for national security or law enforcement work. We need to be able to have access to this data.
Is essentially compromised, even though it's American companies, it's Australian users.
Well, I think, and that's because a lot of the data does get stored on US territory, on US turf. They do have provisions in place, but they have judicial oversight. They have proper process. We do not. We don't have that because Peter Dutton not only ratted on that deal, but has stubbornly refused to listen to business, to civil society, to experts, to be able to do things differently, to achieve what he wanted, but to do it in a proper way that didn't weaken encryption. He wouldn't do it, and now the US is saying, well, should we allow you to get access? Frankly, cheaters shouldn't prosper in terms of the way that Dutton's done this, and he should be held to account for failing to do his job and get this law and to follow the deals that had been struck. And Matthias Cormann should apologise for his cowardice, frankly.
We'll see where it goes. I know the government's essentially delayed it again, and that letter coming from a committee chair over there in the US, so that one has just been released recently. Just finally, we've seen a big focus in the Parliament on Angus Taylor. Why should he stand aside at such an early stage of this investigation? Because
the government's own standards, particularly with respect to a minister that might be under investigation, which we found out that the New South Wales Police will be following this up, would make it incumbent on the government to act and stand him aside. Others have done so, like Arthur Sinodinos in times past, have stood aside to allow investigations to take place. And we are frankly disgusted as a Labor opposition that this government refuses to answer journalist questions, refuses to answer parliamentary questions, treats FOIs and Senate estimates with contempt, And I would strongly urge our side to do whatever we can to disrupt the government, particularly in these last 2 weeks, the government's legislative program, until they demonstrate that they will treat seriously, until they treat seriously the need to be accountable.
To not vote for things until he stands aside, is that what you're saying?
A lot of us, particularly on the backbench, were completely and utterly outraged today when you had, after we had raised questions and they refused to be answered, when we had the Labor leader put forward a suspension of standing orders and they gagged the opposition leader. Now, I've been...
That's pretty standard on a lot of those things.
No, it's actually not, can I just say with respect. Because when we were in government, and I was an MP in that one term of the Labor government, I think it would be highly unusual and rare that we shut down Abbott when he was opposition leader.
How often could you shut him down with the numbers then?
Well,
in the case if you didn't have a majority.
Okay, but I am certain too we would not have even tried it in terms of gagging them, and it's just wrong.
So you mentioned
happen.
The standards say the minister must accept it is for the Prime Minister to decide whether a minister should stand aside. During an investigation, ministers will be required to stand aside if charged. So it's open there, and it's a very early part of the investigation. That actually doesn't say that he should stand aside. There's just an option there.
Well, from the top of my head, I don't think Arthur Sinodinos was charged, and he still stood aside.
It was after some pretty extensive evidence he gave at ICAC.
And I
this
also
is also
think
his office, not Angus Taylor. He's off someone in his office.
I also think. Well, hang on a second. Where's the buck stop then? Where's the buck stop? Like, is Angus Taylor now basically sheeting all the blame to someone in his office, or does the buck stop with him?
Well, but as I said,
he was happy for his name to go in the Daily Telegraph and to create that havoc. He was happy to cause a ruckus there, but he's not happy to be accountable for something.
Well, causing a ruckus is different to actually, as the allegation goes, forging a document. Is my point, but it's step one in the investigation.
So this is part of the course of this government. Well, they will not be accountable.
But you'd agree that this gives an option either way for the Prime Minister.
Let me put it to you this way. If the fourth estate was so happy with the way that this government's been accountable and providing information to journalists, you wouldn't do a whole media campaign on it, would you?